Judge Agius, Vice President of the ICTY, Hilmo Vučinić, Judge of the Court of Bosnia and Herzegovina, Edin Ramulić, NGO activist from Izvor Association in Prijedor, Dr. Zarije Seizović, a professor at the School of Political Sciences in Sarajevo, and Mr. Aleksandar Trifunović, the editor of Buka media project in Banja Luka. We will proceed with the working part of the conference and then open the floor for discussion. A few introductory remarks. Next year, the tribunal will mark the 20th anniversary of its establishment. Its founders, initial staff and judges, and its final beneficiaries could not have known at the time for how long the tribunal will be in existence and what its true impact will be in the region. This calls for a quotation of Ms. Madeleine Albright, who was the U.S. ambassador at the United Nations at the time of the establishment of the tribunal. And several years after the establishment of the ICTY, she spoke about what her colleagues in the Security Council thought at the time. And she said that when the establishment of the tribunal was decided on by unanimous vote, there was a general disbelief that the tribunal will truly come into existence. Once it did, there were doubts that an indictment will ever be issued. Once it was, there was doubt that any trial would see its completion. So there was a general skepticism, not only in the region, but in the international community as well. I can recall similar skepticism when the Court of B&H and its Chamber for War Crimes were established. Dealing with the past and accountability would undoubtedly look different had it not been for judicial proceedings in Bosnia and Herzegovina and in region. The opinions on the achievements and results of the tribunal are divided, especially in the former Yugoslavia, where past still divides people. What is actually the legacy of the tribunal? What is its role in transitional justice and dealing with the past? We will hear answers to these questions from the perspectives of different stakeholders and interest groups, including representatives of the national judiciary, victims associations, academia, and the media. What is the opinion of the tribunal itself?
I said what I needed to say most in my speech earlier on today. Now I will try to focus on some of the issues that I think are very pertinent to the discussions we're holding today. Nerma, how much time do I have?
I'm asking everyone to take 5 to 10 minutes.
Okay, thank you. My message number one, is never be discouraged, never lose hope. Don't look behind when the journey lies ahead. It's easier said than done. Many of you will say it's impossible. You were not here with us, living the terrible times we passed through during the war in the 90s. It's true, I wasn't here with you. But I have been sitting in trials, and I know what happened, and I know very well what happened. I also contributed in my small part as one of the judges of the ICTY to try and establish the truth. And we tried to establish the truth because it is always the point where you need to start from if you are going to embark on a journey of reconciliation and rebuilding of society where the fabric has been very badly torn. I say don't get discouraged. Just think of it. We were created, the ICTY, in 1993. Obviously, the message of the Security Council of the United Nations General Assembly was very clear. Now you have a serious tribunal which will try war criminals. The message was there is not going to be impunity. And yet, what happened? Barely 2 years later, we had some of the worst atrocities here in Yugoslavia, ex-Yugoslavia. Barely 2 years later. But maybe the message had not yet reached home or reached the minds and hearts of the perpetrators. It was too early maybe, yeah, but now it's 20 years past the creation of the ICTY. 18 years or 19 years past the creation of the ICTR. 10 years past, 12 years past the adoption of the Rome Statute of the ICC. 8 or 9 years since its setting up as a functioning court. And yet what do we see? Do we have a situation where war crimes are not committed? Far from it. War crimes are still being committed in many regions of the world, and I don't need to waste your time to mention any particular place. But as I speak now, war crimes are being committed and atrocities are being committed not very far away from here. This is why I say do not get discouraged. Do not get discouraged because there is a difference. You may not think about it when you stop and ponder on what I have just told you. But there is a big difference between now and 20 years ago. Now there are courts, there are tribunals, there are institutions that will investigate, and when the evidence is there, they will prosecute. In some instances, even in absentia, as in the case of the tribunal for Lebanon. So the message that the United Nations sent out loud and clear way back in 1993, that henceforth there will not be any impunity for those who commit war crimes, now is even louder and clearer. And it is strengthened by the record set by the ICTY and the ICTR. The ICTY, as I said before, we have prosecuted 161 alleged war criminals. Some got acquitted, some were convicted, many were convicted, the great majority. So the message now is much clearer, as I said. There's no longer impunity. And this is, in my opinion, the greatest, the most fundamental, the most important legacy of the ICTY. The second most important legacy, according to me, is that we have shown the way. We have made it obvious. We have made it clear for everyone who is interested in prosecuting war criminals that this can be done, and it can be done efficiently, and it can be done with due respect to the fair trial rights of the accused. Ideally, there wouldn't have even been the need for an international tribunal had the system, the structure, and the circumstances prevailing in the various republics of the former Yugoslavia were such that could allow for cases and prosecutions to take place there domestically. But the situation was not ideal at the time. It did not even exist. But as time passed by, now, you yourselves see from your experience here in Bosnia and what is happening also in Serbia and what is to a lesser extent happening also in Croatia, that what we started, namely prosecuting war criminals for war crimes committed during the conflict, can be done even at the domestic level. The legacy of the ICTY is that it has made this clear, but we have also created a structure by which we have assisted you and continue to assist you with, in various ways, with all that is needed for these cases to be instituted and proceeded with. We are proud with what, or with what we have done, because when we come to Bosnia, when we go to Serbia, when we go to Croatia, and we see the special courts operating, we know that we have played, albeit a modest part, but we have played certainly a definitive role in setting up and getting this system go. Another substantial contribution which forms part of our legacy, but again, here one can speak a lot in favor and also quite a bit against, relates to the victims and victims' rights. The statute of the ICTY is not exactly the ideal statute when it comes to victims' compensation in particular. I think the ICC statute is better in that respect, although, of course, I myself am skeptical about certain parts of the ICC statute, especially how the system works. But we have been a platform which would otherwise not have existed, which gave the opportunity to victims to travel to The Hague and tell their story. It is fundamentally important. It's part of our legacy. Victims are perhaps one of the most salient features in the whole context of our discussions today. They are either victims themselves, or they have had victims in their families. We have helped in our small way to give them the opportunity to be heard. we have not provided a good platform or a good system for compensation to victims. That is, however, an important role that you here in Bosnia and others in the other parts of ex-Yugoslavia and the region have a responsibility to shoulder. I'm sure we will be discussing this later on. I have got other things to say, but I'm told my time has come up, so I will round up, close here, and give my colleagues an opportunity to speak. Thank you.
Thank you, Judge.
I am trying to keep up with our agenda so that everyone has enough time to address the gathering. Judge Vučinić, you may take the floor. Thank you very much. I am very pleased that I can talk today about the elements of the ICTY's legacy from the perspective of the judges trying war crime cases before the Court of Bosnia-Herzegovina. From the enactment of the Criminal Code of Bosnia-Herzegovina on March 1st, 2003, which defined that the processing of war crimes and crimes against humanity and protection of international rights is within the exclusive competence of the Court of BiH. It became clear that the cooperation between the Court of BiH and the ICTY and the jurisprudence of the ICTY will be an important link in trying the person suspected of these criminal offenses before the national courts in Bosnia-Herzegovina. We should not disregard the fact that many cases remain within the jurisdiction of the entity courts and the prosecutor's offices, so that the issue of cooperation is the issue that concerns all courts in the country. The legacy of the ICTY is undisputed. It is especially, it becomes especially important in the cases before the Court of Bosnia-Herzegovina, and I will focus on few important aspects. The first one is the normative aspect. The conditions for trials before the national courts are defined in the laws in the field of international humanitarian law, taken over from the statute and the rules of procedure and evidence of the ICTY, and the relevant laws dealing with the crimes against humanity and values protected by international humanitarian law. The criminal offenses which were not defined under the Criminal Code of the SFRI, which was in force at the time of the perpetration, are now defined in the new Criminal Code of Bosnia-Herzegovina dating back from 2003, and the Court of BiH also is applying the general principles of the international law and the international common law. This implies that the crimes against humanity is now a criminal offense in the new legislation, as well as common responsibility in the form accepted in the international humanitarian law, which is as such the integral part of the ICTY statute. The laws also adopted and the solutions adopted from the ICTY are the provisions that are now an integral part of the national law on protection of witnesses under threat and the vulnerable witnesses, and the law on referral of cases from the ICTY to the prosecutor's office of BiH, and the use of evidence obtained from the ICTY in the proceedings before the courts in Bosnia and Herzegovina. This legislative aspect of the ICTY's legacy has created the necessary legal framework and the basis for effective processing of war crimes before the Court of Bosnia and Herzegovina. Another important aspect is jurisprudence. Another important aspect of the ICTY's legacy is its jurisprudence. The theoretical research and extensive analysis of the status of certain criminal offenses were very useful for the Court of Bosnia-Herzegovina, which relies on the conclusions of the ICTY and other authorities in the field of humanitarian law, like Commission for International Law, the ICR, the International Committee of Red Cross, and others. Defining important elements, the key elements of certain acts of perpetration and the standards established by the ICTY is a very important source that the Court of Bosnia-Herzegovina relies on in the trials against the accused for these criminal offenses. Based on the jurisprudence of the ICTY, the Court of Bosnia-Herzegovina started to apply the concept of joint criminal enterprise, which is a form of criminal liability. This is a novelty in our criminal legislation, not only in Bosnia-Herzegovina, but in other countries, countries of former Yugoslavia. As regards the status of the joint criminal enterprise and its forms, the jurisprudence of the Court of Bosnia-Herzegovina, in great part, relies on the jurisprudence of the ICTY, and the verdicts in which this concept has been applied have entered into force, have become final. We should also mention the jurisprudence of the ICTY in terms of command responsibility, especially the standards of proving the jure and de facto command, the factors that are taken into account when assessing the existence of this type of liability. The third aspect is the procedural aspect. As for the procedural institutes and the procedural characteristics in the proceedings involving these criminal offenses, there are a lot of similarities between our procedures and the procedures applied by the ICTY. We should mention here the framework which defines the protection of witnesses and defines the procedure of protective measures. The law on protection of witnesses and the threat to vulnerable witnesses is in essence the Rule 75 of the Rules of Procedure and Evidence of the ICTY. This law gives the opportunity for protection of the victims and witnesses, because witnesses are the most important means of evidence before the courts in Bosnia-Herzegovina in war crime cases, and their role in the proceedings is of decisive importance for a successful finalization of our. All these measures are a novelty in the legislation of Bosnia-Herzegovina, which which originates from the jurisprudence of the ICTY. As for other procedural characteristics, which are the legacy of the ICTY, we have to also mention the use of evidence obtained by the ICTY and the facts established as proven in the judgments of the ICTY. In the effort to increase efficiency in the criminal proceedings in the cases of war crimes, the law on referral of cases from the ICTY to the Prosecutor's Office of BIH and the use of evidence obtained by the ICTY before the courts has been enacted. This law is a novelty in the criminal legislation of Bosnia-Herzegovina. It prescribes the transfer of ICTY cases to the court and the Prosecutor's Office of Bosnia-Herzegovina and the use of evidence obtained in other cases before the ICTY. This is a decisive contribution to the processing of war crimes before the Court of Bosnia-Herzegovina and enables us to use all evidence obtained by the ICTY in accordance with the statute and the rules of procedure and evidence in the proceedings before the courts of Bosnia-Herzegovina. Special attention, this law pays to the provision which defines that the court may use as proven the facts established in another case before the ICTY, considering that the legislative norms only provide for this institute in the criminal legislation of Bosnia-Herzegovina. Generally, the Court of Bosnia-Herzegovina had to rely in its practice on the criteria established by the ICTY concerning an eligibility of a certain facts to be accepted as proven without violating the right of the accused to a fair trial, which is guaranteed under national legislation and many international conventions. The majority of verdicts passed in Section 1 of the War Crimes of the Court of Bosnia-Herzegovina. Many parties argued these accepted facts, and I have to mention that even the defense is also using this institute. So this instrument lives, and some issues are no longer the matter of dispute, and it is accepted that the evidence obtained by the ICTY can be used before the national courts, and the use of evidence obtained by the ICTY and accepting facts as proven, the facts proven in the ICTY are not in contravention of the European Convention, but the use of that evidence may not question the fairness of the entire proceedings. However, the court now needs to introduce the same jurisprudence and the same point of view before the entity courts to enable that these processes in the Court of Bosnia-Herzegovina also take place before other courts that will try war crimes for years to come. We can conclude the following. I think that the legacy of the ICTY Undisputed and that its importance is huge for the judiciary of Bosnia-Herzegovina. If we take into account that since 2005, when the War Crimes Department was established, until September 2012, 90 cases of war crimes were finalized against 122 accused, while, for example, before ICTY, 126 persons were accused, and the ICTY needed the period from 93 until 2012 to complete the trials in these cases. Efficiency of the proceedings is also contributing to general dealing with the past. The importance of the ICTY legacy for the victims is in the fact that many materials must be available to the citizens of Bosnia and Herzegovina to preserve the legacy, not only in terms of its professional importance, but for general public. The legacy also pertains to the issue of the state war crimes strategy. In that regard, the Court of Bosnia and Herzegovina is highly interested in the defining of partnership of sorts between the ICTY and the Court of BNH in terms of digital and physical availability of archives and jurisprudence to the Court of Bosnia and Herzegovina. All of what I mentioned marks the contribution of the ICTY to the capacity development of the Court of Bosnia and Herzegovina that needs to face the challenges of processing war crimes cases that remain complex to this date. Let me remind you that there are 1,316 cases before the prosecutor's offices in Bosnia and Herzegovina, 653 of those being before the prosecutor's office of Bosnia and Herzegovina. This means that great challenges lie ahead for us in the processing of war crimes cases. Thank you very much. I will speak today about, from the perspective of victims' associations. Given the fact that the tribunal was at a great physical distance from the victims, not many of them had the opportunity to get in contact with the tribunal officials, including those who visited the region. Therefore, the influence of the political community and the media was very important for the establishment of the relationship between the victims and the tribunal here. Most frequently, we hear criticism about the number of the cases processed before the ICTY, the lengthy proceedings, and from the perspective of certain associations, the problem of ethnic makeup of the accused appearing before the tribunal. This is a result of the general lack of understanding about the nature of the tribunal as the institution and its institutional role. We had certain parts of the country that were reluctant to cooperate in the beginning. We still have victims' associations that have never even tried to act as partners to the tribunal. That is one of the reasons, perhaps, why the visibility of the tribunal's activities was not that high in certain parts of the country, and why certain victims associations did not take a more active role in cooperation with the tribunal. The contribution made by the tribunal is immense. There is no doubt about that. The war crimes trials, the establishment of new courts in the region, and other aspects of transition justice. I will focus in my presentation on the negative aspects. I believe that there will be many other speakers today who will talk about the positive aspects of Tribunal's legacy. What we can say first is that the Tribunal put victims in the background. All resources were directed towards providing the accused with full observation of their procedural and statutory rights, whereas the victims as aggrieved parties remained in the background without any significant effort being invested not only in the reparation of victims but also in informing them timely and adequately about the developments at the tribunal. The majority of aggrieved parties do not even receive the judgments of the tribunal, and the only source of information for them is the media. In terms of justice for victims, the judge from the tribunal talked about the importance of giving the opportunity to the victims to speak and have their voices heard before the tribunal. But what about victims who were not included in the cases processed before the ICTY, or who were part of those cases but were not summoned, or those who were contacted as potential witnesses but were never summoned to appear and testify, or those who were considered and proposed as witnesses but then abandoned in the course of plea bargaining and admission of guilt. Victims who have not had the opportunity to have their voices heard before the tribunal, to get in direct contact with the justice brought by the tribunal, remained numerous. We also faced a very important issue that is considered a problem, and that is lack of standardized punitive policies, short sentences that were additionally mitigated so that many of those sentenced by the tribunal are already free. That is something that the victims consider very unfavorably. There are many accused persons who have appeared before the ICTY and who now walk freely and meet the victims of their own crimes. Victims were generally not made a priority before the ICTY. Also in terms of their identification, not enough effort was invested to identify all the victims at a certain location, and as far as the problem of missing persons is concerned, the tribunal has not done enough to shed light on the demise of these people. Plea bargaining was not sufficiently used for identification of victims. All four accused for the Karaterm camp entered into plea agreements. However, more than 100 missing prisoners from that detention camp remain missing to this date. We believe that the plea bargaining could have been used better to resolve their fate. The proceedings currently pending are extremely important. The remaining cases
especially in terms of the ICTY legacy. I believe that in view of these last cases, the public will judge the entire work of the tribunal. That is why the decisions, such as the last decision to drop the genocide count in the Karadzic case, suggests that the tribunal is trying to accelerate the proceedings, to complete the proceedings as soon as possible. I think that the basic problem, generally speaking, is that everything that happened during the war, and in terms of the ICTY legacy, all the concepts now are applied by the national courts. And the courts do not pay too much attention to the injured parties, to the victims, but do not focus on finding the missing persons, and they adjust the jurisprudence to the norms established by the ICTY. But what is perhaps the biggest problem is this incorrectly conveyed message to the national courts that not everyone can be prosecuted, meaning that they should not be prosecuted because of the limited capacities, because of the large number of war crimes, because of the large number of very, very serious, complex crimes. It creates this impression in the public and also through the media and the politics that not everyone can be prosecuted, which in this context of struggle against impunity is very important. It is not sufficient to only say that those were crimes committed en masse, and that would be, in summary, my presentation. Thank you, Edin. Now I will give the floor to Dr. Zarije Seizović, professor. I would like to thank the tribunal for inviting me to attend this conference. My colleague, Judge Agius, he talked about the initial skepticism that accompanied the establishment of the ICTY. Allow me to tell you something that happened during the visit to the Permanent Court in The Hague. We talked with some senior legal advisors there, who told us that the Minister of Justice, this advisor worked in the Ministry of Justice at the time, he said, "Have you ever been to New York?" And he says, "No." "Would you like to see New York?" He says, "Yes." So he says, there is some rumor that there will be a permanent criminal tribunal established. That will not happen, of course. The minister says, "But you can take your wife and spend 15 days in New York." There are some rumors in the United Nations about this court. He agreed, and this was in February this year. After 15 years later, we were sitting in the court that started processing the cases and is now the guarantee of prevention of war crimes. This is just a short introduction. The same skepticism accompanied the establishment of the ICTY. I was an idealist, and I believed from the very outset that the tribunal will achieve the results that it did achieve eventually, and that we are discussing today. I am a person representing the academia, and this topic is proper for us, and that's why I suggested this topic, the facts established by the ICTY, as an important means of struggle against impunity, revisionism in academic discourse. Important topics that the ICTY considered are as following: the personalization of guilt. Individuals are standing trial, persons with identity numbers, with the residence, with the full name, with fathers' names indicated, meaning specific individuals. The ICTY has made the guilt personal. Political leaders cannot hide behind people or any groups. that they belong to based on the collective identity concept. Further on, the tribunal has a very interesting role as a historian, as someone that records history. Lawyers know what res judicata means. It's a tried thing when certain case has been decided on. It contains historical facts, and it should not be discussed, but these facts should be accepted. Established facts or adjudicated facts that were established in final court judgments or decisions have been established beyond a reasonable doubt. That is an Anglo-Saxon standard that our legislation here did not recognize, but we can say that these facts have been proven. Admission of guilt as an institute that was taken over from the Anglo-Saxon system and has been enforced since 2003 in Bosnia-Herzegovina, for example, in the Plavšić case. And in general, admissions of guilt are very important because it did not include presentation of evidence. A person, an individual, admitted doing something, committing a war crime, and regardless of whether that person showed regret or not, his or her admission is important because those admissions were not the result of the presentation of evidence, but the expression of the person's free will. Finally, establishing or adjudicating on the facts of crimes committed in former Yugoslavia is very important in fighting against the practice of denial of guilt and revisionism. I would like to say a few things about revisionism, which is a tool to deny something that cannot be denied. Those are facts established in the courts, in the national courts and international courts as well. Historical revisionism is the re-examining of the existing facts about the event or negative distortion of a historical record through which someone is trying to portray those events in a better light. Denying the facts of crime is often called negation or negative aspect. It is usually implied in war crime cases and employs different techniques of revisionism. The reasons for that are as follows. First of all, revision attempts to influence ideology or policy with national or state goals in order to transfer guilt for war, to demonize the enemy, to affirm the illusion about the victory and similar. In broader context, there are two basic motivations for historical revisionism: to control the influence, ideological influence and political influence. Ideological influence, talking about it, the revision of history ensures power to create ideological identity or metrics. Revisionists, they create pseudo-history that is now placed within a certain political, social, or ideological concept with relevant goals. Political influence, revisionists, they usually place or introduce certain myths. Self-proclaimed amateur or dissident historical approaches, they manipulate and portray incorrectly historical events to support certain political goals. The techniques of revision are different. There is a whole series of different techniques. I will mention few, but all of them rely on misconception and misleading. These techniques would portray certain documents as not original, raise doubt about certain documents, manipulate about certain facts, incorrect translation of certain texts and documents, and similar. Today, the global use of internet is very suitable for these techniques. Some states even denied these negative revisionism of certain facts, as historical revisionism is used to deny or to influence the interpretation and perception. it can be considered as a form of propaganda. Finally, revisionism operates within the sphere of intellectual activity to ensure certain interpretation or perception of history. Denial and relativization are three key techniques.
The use of incorrect information, lie, manipulation with the truth or opinions or information in order to further certain political or ideological goals. Credible sources and reviews of or peer reviews are used in proper criticism, whereas those aiming at misleading use improper techniques. In this context, the ultimate goal would be to prevent the publishing of information or to claim that the information published is not correct. There can be preventive techniques such as transfer of guilt, censorship, distortion of information, media manipulations, and so on. And finally, relativization or trivializing would be comparing atrocities to other, so to say, lesser crimes as an instrument of revisionism. That is called relativization, that offers no new facts or evidence, but establishes moral opinions and standpoints on a certain atrocity and results in ultimate equalization between crimes such as crimes in Japan or genocide against the Armenians or Stalin's regime in the Soviet Union. Ideally, in an objective, emotionless environment, lessons in schools and universities would be exclusively based on facts established by the final judgments of the ICTY. Any other approach would be considered as revisionism. Special emphasis in that regard should be placed on educating people on non-existence of collective guilt. Thank you. And Mr. Trifunović, thank you. Good morning. I may have a different view on this topic and this gathering and conference today than my colleague panelists. I think that 20 years later, we should talk about the effects, the impacts, the achievements, the results, about our understanding of what is happening to us now, what happened to us in the past, and what can we prevent from happening in the future. ICTY, as the most powerful institution judging war crimes, did it contribute to making sure that the past will not repeat in Bosnia and Herzegovina? In my opinion, it did not. In my opinion, the tribunal was exclusively the instrument of the international community and the politicians in Bosnia and Herzegovina. And least of all, it was to the benefit of the victims. Carla Del Ponte, who tended to appear as Mick Jagger in her public appearances, when she was here once, she remained in the room during one of the conferences while all the media were there, and then she simply left and victims stayed alone to exchange their painful experiences. Today we see the representative of the European Union leaving immediately after his introductory speech. Most of those convicted before the ICTY, upon their return to their native countries, were met with honors by their political leaders, by officials of that country. No one mentioned their established guilt or the sentence they served. The ICTY could have done much more to prevent this, but I'm afraid that 20 years from now, the influence and impact of the ICTY will not be as strong. I believe that resources should have been used better to advance the dealing with the past. In addition to the judgments, people should have dealt more with not only with crimes against us, but crimes committed in our name. It seems to me that the judgments were only used as instruments to divide the society further. And now we see a society divided to its roots, left to generations that hate each other more than their parents did back in the 90s. And the ICTY, 20 years later, there was a humorous portal in Serbia that published a text once about how countries of the region should agree on whether the ICTY was anti-Bosniak, anti-Serb, or anti-Croat, because everyone used it as their punchline for daily political talks. 20 years later, when I ask myself, could the tribunal have done more, I would say yes. Not all of it, of course, but the cooperation should have been better with other institutions. The tribunal should have played a greater role in the reconciliation process. I hope that today's gathering will be a forum for the discussion of what else can be used of the tribunal's legacy. But as I said, I believe that the early departure of the EU representative this morning demonstrates the position of the international community towards the legacy of the tribunal and what it can do in this country. Thank you. As we've heard, there's the feelings are divided about the legacy of the tribunal and its impacts. We heard from the victims, from the judges, from the media, and the relationship of the tribunal with the efforts of revisionism and negationism here. We can use the half an hour we have left to encourage you to ask questions. Before we start, please bear in mind that you have to use a microphone for the recording. So when you're given the floor, please wait for the microphone. Ernesta will hand you a microphone.
Ja mogu da početi? Može. I samo se predstavite, molim vas, za transkript, da znamo koga. Moje ime je
Kada Hotić, Association Mothers of Žepa and Srebrenica Enclaves. I would like to greet honorable judges of the ICTY and the judges of our court in Bosnia-Herzegovina and everyone present. We are talking here about the ICTY legacy and what will remain after ICTY for our future. As a victim, I can be partially satisfied, and on behalf of our association, I can also be partially satisfied. I come from Srebrenica. Genocide was committed in Srebrenica, which was proven before the ICTY. It is very important for Bosnia and Herzegovina in general, but still, 20 years of existence of the court and 70 years after the genocide in Srebrenica, still the war that occurred in former Yugoslavia does not have its proper name yet. And that is why I am not satisfied. Not one institution or state has been prosecuted and tried who were initiators of the war. Is it possible that individuals could commit genocide? Is it possible for an individual to start a war? Was it possible for this evil to happen and only try individuals, which is unacceptable for the victims? There are many individuals. Only in Srebrenica, it has been established, the commission established that out of 24,000 persons were involved in the crimes. Of course, not everyone can be prosecuted, but the initiator of that evil has to be identified and held accountable, because that will be the legacy for the future. And to warn everyone not to cause a war like this one and not to have casualties. And even those who were sentenced to mild sentences, I don't see what will come out of it. And the regret that Plavšić expressed to get a smaller sentence when she was released, she made it clear to her people that she would do it again, which means that she was not sincere in her regret. We are not so much satisfied as victims. This involves entire Europe and the Security Council and the United Nations. So it is not surprising that the rules in the ICTY are as they are. Thank you. Thank you, Mrs. Hotić. I think we will first hear 2 or 3 questions and opinions, and then I will give the floor to the panelists to answer. I wrote down your question and your comments, Mrs. Kada. Now we will move on to others. Nedeljko Mitrović, representative of the organization Families of Former Detainees and Victims of Republika Srpska. I express my deepest respect to the organizers who are trying, and including the victims of war, to contribute to the effort of the ICC and the ICTY with respect to the legacy. And since we didn't have the opportunity to give some comments about the persons who made introductory remarks, who did confirm that their presence, we thought that they would be present here throughout the conference. They gave introductory remarks officially. The mayor gave out some opinions without giving us the opportunity to ask certain questions and get answers to those questions. Even though the mayor is not present, I will nevertheless say a few words for the sake of the record that will be made of this conference. Mayor cannot say tragic event, tragic conflict, and then say aggression and then refer to the siege. I want to make some comments. The entire Bosnia-Herzegovina was under siege, and entire Yugoslavia at the time. We have to understand that, and we have to accept that. Who imposed this siege? Who initiated this blockade? That's another question. Mr. Mayor cannot say that 20 years of siege, of shameful siege. Let us recall that there were 20 years of constant outvoting of one of the constitutional peoples. I will also refer to the referendum. The murder that took place even before the war of the Gardović in the wedding ceremony, and no one was held liable for that. Sarajevo is portraying itself as a multi-ethnic, apolitical town, the town for all citizens, for everyone. So how are we going to call this Sarajevo romp Sarajevo, like we referred to Yugoslavia as a romp Yugoslavia? Is Sarajevo also Istočno Sarajevo? We should also have the mayor of Istočno Sarajevo present with us in order to perceive Sarajevo as one, as a whole. That is my first impression. And it suggests that the persons present during this conference that not all persons present at this conference do not have the best intentions in the approach of this program and to have this legacy available to the persons who will need it the most. But the Vice President of the Court, I apologize for my words, for making this presentation. It is disputable what you said, that there is comfort for the victims in Bosnia-Herzegovina. I will tell you that as representatives of some organizations, we don't see that comfort. Mr. Dukic is a former camp inmate. My colleague sitting next to me on 26th of March, his mother and his brother were killed. Just a second, please. I don't have the opportunity like you to speak at the tribunal and to speak at conferences like this one. We are restricted in that matter, as we were restricted on the 24th February 2010. We were restricted, limited. We had to extort comments. We couldn't get a visa approved to travel to the Netherlands if you can travel. This is my short comment. I want to respond to Mr. Ramulić. For a great part of his presentation, he was right. He cannot represent the victims of war as a moderator, or I don't know how you call him, what you can call him. Because in his comments, he only mentioned the Karadzic case. There are Karadzic cases on the other side as well, on the opposing side as well. We have to have authentic representatives of all people to discuss the consequences of war. I will have a lot of comments, but I know that I cannot take all the time. Please don't comment while I'm speaking. I was silent while you were making your comments. Please wait for the microphone and wait for your turn. Try to be focused in your comments, and if you have any questions for our panelists that are relevant. Mr. Mitrović, just a short reply. You know that we invited 200 people in this conference room. We cannot have every person sitting on the panel and being a panelist. That's why we planned accordingly and left enough time for everyone to take active part and say a few words. I would like to greet everyone present. Mr. Grabovica, President of the Association of the Parents of Killed Children in Sarajevo from 92 until 95. I have attended similar conferences in the past, and I always attend with intention to discuss about justice, to talk about something that can create conditions for future generations. And what happened here in the 90s never happens again. However, I'm under the impression that often persons who attend such gatherings come for different reasons, and I have a feeling that some political connotations are introduced through their comments. As Mr. Trifunović said, and he summarized it perfectly, so I don't want to repeat what he said, but I would follow up on that, and I would like to ask the representatives of the court and the prosecutor's office, I would like to ask them what has been done with reference to General Tomislav Šivčić, who was the commander of the Sarajevo, Romania Corps, and who kept this town under siege, and he was a commander for a short period of time during 1992, from May until September. And during that period of 4 months, 138 children were killed. This is what we know, what has been established, and that number is much greater. And I did not include the numbers of the adults who were killed. I would like to ask everyone present at this conference whether and how would they feel if one day someone would kill the purpose of their lives, someone they love the most, their children, in such a brutal manner in which children were killed through snipers and by shells. And if one of the parents, if they as parents would lose both children at once, or if the entire family, including their parents and children, perishes. That's what we need to think about and talk about to prevent it from happening again. We, the parents, who suffered those losses, we do not hate, we do not want to retaliate, we only want justice and better future for the next generations. Thank you.
Dobro, hvala. Dame I gospodo, ja sam Branislav Dukić.
Ladies and gentlemen, my name is Barislav Dukić and I am the representative of the Association of the Former Camp Inmates of the Republika Srpska. I would like to greet everyone. I attended one similar conference at The Hague. Unfortunately, the same stories are told. I can see the same setting, more or less, and I had to react hearing the presentations of the panelists, and our countrymen from Banja Luka shared completely different views, disagreeing with the discussions. I want the international community not to intervene in Bosnia-Herzegovina anymore, and I want to tell them that what we have been suffering for 20 years, we have suffered even before the 90s for 20 years because they wanted to destroy Tito's Yugoslavia, and they are successful. They have been successful. Bergman came here, gave a nice speech, and he says, "Hear us in Sarajevo. I am a person from Sarajevo. I want to see people who lived in Sarajevo during that time." So 5 of us, dear gentlemen and dear ladies, out of the hundreds, and that's the story of Sarajevo. They come here talking about Sarajevo, and then they say there were 11,000 victims, and no one wants to. Please, lady, don't interfere. This reminds me of the assembly and Alija Izetbegović in '92 and the outvoting. Do you want that to take place again? Please, you have to let others speak and not interfere. You will all have the opportunity to speak. Mr. Bergman said, let us put these documents in the town hall, but it should also be placed in Banja Luka and in Mostar as well, because all 3 people have criminals among them, people who committed crimes. And we have judges here who can talk about that. But who set the town hall on fire? Mr. Bergman doesn't want to say that. Probably Karadzic, probably him. It was us. I set it on fire together with others who were in Sarajevo with you. This is reconciliation. This is Bosnia and Herzegovina. I would like to say more comments, but since I don't have enough time, then we will move on. I would like to check now if one of the panelists would like to respond.
Did you want to answer one of the questions about the individualization of the guilt and some of the points that have been raised? Did you want to address some of the points that have been raised?
To be frank, very little was addressed to my intervention. I frankly think it will be much wiser and better if the other members of the panel dealt with some of the issues that have been raised. I mean, my concern, more importantly, than answering to some of the comments made regarding the tribunal, is how it is emerging very obvious that rather than embarking on a journey of reconciliation, on a journey to avoid another conflict, a journey to bury the past, bury the hate, and embrace forgiveness and a determination to move ahead, we have a tragedy developing before our own eyes. And this is of a great concern. This is of great concern. This is not the legacy that we left you. This is not what we would like to see in Bosnia and, for that matter, in other republics of former Yugoslavia. This is not what should be happening. This is not what you should be. You should not be arguing about the past. Let the judges decide about who is guilty and who is not guilty about the crimes that have been committed, for the crimes that have been committed in former Yugoslavia during the war. Let the prosecutors investigate and bring people to justice before the courts that you have instituted here. Let the judges decide. And you embark on a social and political journey towards peace, reconciliation, and nation rebuilding. This is what you need. You don't need another conflict. You don't need to continue arguing amongst yourselves. If you continue to do this, we may have left you a legacy, but you are throwing it away to the dogs. So I think I should leave, let my colleagues.
I noted two questions. The question about the general whose name was mentioned. I can tell you about the indictments that were confirmed before the court of Bosnia and Herzegovina. That name is not among the confirmed indictments. Referring to the person you mentioned. As for the indictments pending, I cannot comment on that. Regarding the question of the nature of the war, it is correct, Madam, what you said, that both the ICTY and the Court of Bosnia and Herzegovina failed to define the nature of the conflict in any of their judgments. A simple reason for that is that there were no indictments raising the issue of the nature of the conflict, and there was no need for us to establish such nature ex officio. If in future some case should arise raising the issue of the nature and type of the conflict, the court will deliberate on that. For the time being, there are no cases where the nature of the conflict was raised as an issue whose adjudication was required. We refer to the Geneva Convention number 3. We take care of the categories of protected persons without going into deliberation on the nature of the conflict. In regards to everything that was said here, conference in Belgrade, it was an impressive gathering of many international representatives, many lawyers, judges, prosecutors, representatives of victims associations, and one day the delegation from Bosnia and Herzegovina sat at a large table during lunch. No one spoke to anyone. And a certain number of people dealing with the protection of victims, I wanted to tell them this: if you're all dealing with the same issues, and they are, but from different perspectives, so my remark to them was, if you're doing the same job, why don't you try to reach a common ground, a common standpoint, to use it as a baseline for your approach to the institutions? And they all attacked me as if I was the bad guy there. So, having heard the comments here today, it seems that not much has changed, unfortunately. Dr. Seizović, thank you. The first thing I mentioned is personalization of guilt. And I think that its perception in the Bosnian society and the societies of the region is not quite clear and proper. When we use the notions of us and them, when we use these pronouns to mark collectiveness, we fall into this trap of discussing collective guilt, whereas guilt is something established by the court in reference to someone with a name and surname. Why would someone of this and that ethnicity have any problem with the crime committed by the member of the same ethnicity? Why would a Croat from West Mostar feel guilty for the crimes committed by Tuta or Štela? Why would someone from Banja Luka feel guilty for or concerned about someone being sentenced by the ICTY? This is not the perspective we should all have. I understand the pain and the guilt, the pain and the sorrow as emotions buried deep inside. It is tragic when someone's child gets killed. But the first step, 20 years after the establishment of the tribunal, would be to understand that it was not a crime committed by us, committed by them against us. It is a crime committed by a person with a name and surname against an individual. Mothers are mothers everywhere. In Banja Luka, in Mostar, in Sarajevo, their interests are the same. They want to find the remains of their children and give them a decent burial. Of course, there are national interests. But the interest of a university professor from Sarajevo is similar to the interest of the university professor from Banja Luka or from Zagreb. To cut the long story short, and to avoid being too emotional, and it's difficult not to be emotional in circumstances like these, I would like to underline that crime is a legal notion, having its legal definition, having its key statutory defined elements, and that crime was committed by someone with a name and surname. Us, them, and the counting of the years of prison sentences is meaningless, and it cannot be discussed in the context of collectivity. Whoever has anything to offer in terms of evidence, in terms of criminal charges, should bring them before the relevant authorities. I will also give the floor to Mr. Trifunović. Just please, Kada, please. Please wait. You cannot address the gathering without the microphone. I will only follow up with a few sentences. Mr. Vučinić said it a while ago. To follow up on that, where are we now, 20 years later, 20 years after 92, and can we do better than this? What differs us from animals is compassion for another human being. Once we start respecting another person's pain as a human being's pain, once we go beyond the ethnic circles and communities and limitations, that's when we will be able to be humans again. We have to discuss what happened. We have to live together here. We have no other choice. But can we do better than this? That's what I'm concerned about, and my disappointment is greater than it was 20 minutes ago. Thank you. We have to stick to the schedule. I noted down all of you who wanted to ask questions but were not given the opportunity to. We will have the second panel that will also provide opportunity to ask questions. Let me thank all our panelists. As we've heard, this is quite an emotional topic, and I hope we will reach some specific conclusions by the end of the day. We have half an hour coffee break. We will resume at 11:30.